Please stand with me. When he does, put a mirror up. Okay, for 5 minutes, you'll be open for Hey.
And it's all little where
Well, let's check while I ask the question. Hey, guys.
Hi.
How long you think you're gonna be? Because the next guy's a gangster, so I want to make sure, we got time to get it done here.
Maybe 15 minutes?
15, 20 minutes you are?
15, yeah.
Roger that. Good luck. Thank you.
Good morning, Mr. Hall.
Good morning.
Morning, we're here for your revocation hearing today. I have your attorney, so we're going to get started with that, okay?
Yes.
Good morning, I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is revocation hearing concerning Hall Rasheem number 315496. Today is January 6, 2025. This hearing is being conducted via video at the BOPP Central Office in Corrigan Correctional Institution. This is a public hearing, and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Rasheem Hall, 315496.
And you have counsel here today, please identify yourself.
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
Good morning, sir.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, the state appeals ran against you. I will review and identify exhibits filed for the record. You will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today. The right to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
All right, so we will now review the charge, state appeals written against you, and information underlying each charge. Charge 1, release section GPS, your charging officer reported you allowed GPS unit to shut down the following dates: 4/2/24, 4/10/24, 4/13/24, 4/14/24, 4/15/24. According to Allied Universal, the last point recorded for your GPS unit was 4/15/2024 at 5:32 p.m. Charge 2, under release section curfew. Charging officer stated you did not return to your approved parole residence by your 8 p.m. curfew on the following dates: 3/24/24, 3/29/24, 3/30/24, 4/1/24, 4/2, 4/3, 4/4, 4/5, 4/6, 4/9, 4/10, and 4/12/24. On release, charge 3, release section program participation. I make this into 2 parts. Part 1 states on March 19th, 2024, you have unapproved visitors at the Reach apartment, which is in violation of your Reach contract. Visitor policy number 3, visitors not to be left in the apartment when the individual they are visiting is not there. Part 2 states on April 2nd, 2024, you received an infraction from Reach staff after smoking marijuana in the Reach residence, which is in violation of your Reach contract. Number 14, I understand that smoking is prohibited in all apartments. Charge 4, WL laws obedience to the law. Focusing on the 2 parts. Part 1 states on April 15th, 2024, you're involved in a motor vehicle stop in the city of New London. You were issued a summons for misuse of plates, operating an unregistered motor vehicle, driving without a license, and driving without minimum insurance. After New London police conducted a motor vehicle stop on the vehicle you were operating. Part 2, on April 17th, 2024, you were arrested after you were involved in a physical altercation with your victim. The victim reported you stated that you were going to kill her before going back to jail. You then proceeded to get on top of her, choking her with your hands, elbows, and punching her in the face. Subsequently, you were arrested for strangulation 2nd, assault 3rd, threatening 2nd degree, and disorderly conduct. Charge 5, under conditions, no consumption of alcoholic beverages. Charging officer reported on March 21st, 2024, you reported to the Norwood District Office and rendered a urine toxology, which was sent out to Premier Biotox Labs for alcohol confirmation. On 3/26/24, Premier Biotox confirmed the presence of alcohol in the urine toxology you rendered on 3/21/24. Charge 6, under behavior management program. Charging officer reported on April 15th, 2024, you're unsuccessfully discharged from the Explore program after violating the program's attendance policy. Charge 7, under additional conditions, no contact with victim. Your charging officer reported on April 17th, 2024, you were arrested by Norwich police after you were involved in physical altercation with your victim, BR. At the time of your arrest, there was an active order of protection in place with BR as the protected person, and you are as the respondent. This order of protection has expiration date of 12/31/9999. And the state has filed the following exhibits that are pre-marked for identification purposes as: Exhibit A, signed Connecticut Conditions of Parole. B, Connecticut Department of Correction and Remand to Actual Custody Order. C, Notice of Parole Violation. D, Parole Violation Report. E, LI GPS Monitoring Event Summary Report. F, GPS Monitoring Agreement. G, Explore Discharge Summary. H, Premier Biotox Lab Report. I, Norwich Police Department Report ending in 15630 AR. J, New London Police Department Summons. And K is the Connection Progress and Discharge Reports. And did you receive the notice of parole violation report, and those other documents I marked? Did you review those?
Yes, ma'am.
And counsel has filed the following exhibit pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. And Exhibit 2 is the offender work performance and program form. Do you need to continue sharing to obtain any additional evidence?
No, we do not.
We have no witnesses. I am going to put on the record, we do have an addendum from PCS. The addendum reported on November 27th, 2024. You were convicted of strangulation, suffocation, second. Received a sentence of 5 years, suspended after 2 years with 2 years probation with all other charges nullied. I have an EOS date of April 17th, 2026 on those charges with a eligibility date of 12/28/25. So is now defense opportunity. If you'd like to speak at this time?
Yes, regarding the charges, regarding the charge 4, I don't believe there's enough evidence to meet the preponderance of the evidence standard regarding the first part of that, regarding the motor vehicle stop. And regarding charge 3, I don't believe there's sufficient evidence about the unapproved visitors. Thank you.
Right, so I'll be right with you with my findings. So, but now to my findings. So on charge 1, I do find that you violated condition release direction GPS based on evidence that was provided, which is exhibits A, E, and F. On charge 2, I do find you violated condition curfew based on the evidence that was provided, exhibits A, E, and F. On charge 3, I find you violated condition release direction program participation on part 1 based on evidence provided in support of the charge, exhibits A and K. I make a no finding on part 2 due to there being insufficient evidence to support the charge regarding that date. On charge 4, I find that you violate condition, obey all laws, obedience to law on part 2, based on your conviction of strangulation, suffocation, second, received a sentence of 5 years, suspended after 2 years with 2 years probation with all other charges nullied. Part 1, I make a no finding based on the evidence, based on there being insufficient evidence to support the charge. And we'll note those charges were nullied. On charge 5, I do find you violated condition, additional board condition, no consumption of alcoholic beverages based on the evidence that was provided, A through D, in particular G. On charge 6, I find you violated condition behavior management program based on the evidence that was provided, which is exhibits A and G. On charge 7, I do find you violated condition, additional board condition, no contact with victim based on evidence provided, which is exhibits A, D, and I. So that concludes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes. My client's early release date is December 28th of 2025. We would ask for that date as a release date. He is a divorced 39-year-old gentleman. He receives his primary support from his sister. His mother currently suffers from dementia. He has 4 children, and Mr. Hall pays child support for all of his children. They are 19, 16, 13, and then 15-year-old son. He is very active in his church. He wishes to reunite, and there is involvement with DCF regarding his youngest daughter. He wishes to reunite and get partial custody with her. He has completed the Connecticut Renaissance program. He was enrolled at Three Rivers Community College, where he was studying business administration and human services. He's worked excellent work history. He's worked at KFC, Domino's. He worked and he has been offered an opportunity for a union job in North Stonington at a steel mill. He's worked in the past as a trainer at Burger King, Allied Van Lines. He was in Reach and he shattered his hand, and unfortunately he was unable to work temporarily. He was also worked at a Sunoco gas station. While incarcerated, he has been working as a dietary aide in the kitchen since February of 24. He has been in the men's recovery promotion group. He's actually engaged in group discussions. He completed 15 of 26 sessions of Explore. He will participate in the AIC Building Resilience Program. He wishes to be placed in a halfway house in Norwich. and eventually transition to a reach bed. He wishes to return to study business administration and human services. He wishes to re-pursue the steel mill opportunity with the union, and he's eager to obtain custody of his youngest daughter. He did receive a lengthy sentence here. We just asked that he now receive the 2 years and have to serve 100% of that sentence since he is eligible for release on 12/28/25. Thank you for your time and consideration.
So I'm gonna put.
Just briefly,
Yeah.
his PO, this is only his second violation. He only had his second violation. He only had 2 graduated interventions and sanctions since September 1st of 23, and his PO recommended a 1-year period.
Thank you. So, I will put on the record, you were only at the 7.5 months before you were returned to custody on new charges. You do have a prior technical violation on this period of special parole supervision, as well as received 2 misconducts. You did receive the charges you were convicted of are similar to the reason that you're on special parole for in the first place. And that's what's concerning to me, is that you continue to display this same type of violent behavior that you're currently already on parole for. You are on supervision until July of 2027. And it is also concerning that you didn't complete the programming while you were out there, and instead another domestic violence incident occurred. So I hope you're using the time in there to actually get engaged in the programming and everything like that, so you make better choices when you do come back out. I am going to recommend, based on this information, that you be, that I recommend parole be revoked, be re-paroled for April 17th of 2026, which is an approximate 2-year period of confinement as a sanction. This is the offender's EOS date on the new conviction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, behavior management program for domestic violence, no contact with your victims SL and BR, as well as operation of a motor vehicle. My findings go on the parole board. It will be presented to them on January, I think it is. Let me just double check. I think it's the 16th. Yes. So January 16th, I'll present this to the parole board. They're going to make the decision. They can lessen it as soon as that December 25 date. They can keep it the same. They can make it anytime lesser than what I had. They can also take away all special parole. So it's going to be up to the parole board. You'll be notified about a week after, or you can also speak with your attorney regarding what the board's decision is. Do you have any questions?
No, ma'am.
Call me if you have any questions, okay, sir?
All right, thank you.
You're welcome.
You're all set. Good luck, sir.
Okay. Got them all here.
Thank you very much. Morning, Mr. Maldonado.
Morning, how you doing today?
Morning, sir.
Good. We're going to get started in a minute with your revocation hearing.
Yes, ma'am.
Good morning, P.O. Huff. Are you logged on?
Good morning. Yes, I am.
Perfect. All right. So we're going to get started with the revocation hearing. Good morning. I'm P.O. Meisinger, a hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing concerning Maldonado, Orlando, number 299666. Today is January 6, 2025. This hearing is being conducted via video at the VOPP Central Office in Corrigan Correctional Center. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Orlando Manuel Maldonado, 299666.
Thank you. We also have a parole officer present. Can you please identify yourself for the record?
Parole Officer Huff, Hartford Special Management Unit.
Thank you. And we have counsel here today. Please identify yourself.
Yes, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
No.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today, right to have an attorney present, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case at this hearing. You have a right to call and examine voluntary witnesses, cross-examine adverse witnesses. Do you understand these rights? Are you ready to move forward?
Yes, ma'am.
Okay, so we'll now review the charge. The state, your PO is bringing against you and the information underlying each charge. PO Huff, will you please read the charges?
Yes, ma'am. Charge 1, GPS. You feel the charge of GPS as directed, resulting in battery violations on 3/12/24, 3/13/24, and 3/15/24. You sign a misconduct acknowledging this behavior on 3/20/24. You failed to go directly home as previously directed due to your late work hours on 5/16/24 and were at an unapproved location from 3:53 a.m. until 5:54 a.m. You sign a misconduct acknowledging this behavior on 6/4/24. You were directed to stay away from your girlfriend's residence located at 99 Willis Street in Hartford due to the presence of minor age children at the residence. You were at the residence for a prolonged period of time on 5/17/24, 5/18/24, 5/19/24, 5/20/24, and 5/21/24. You signed a misconduct acknowledging these behaviors on 6/4/24. You again visited your girlfriend's residence on 7/9/24, 7/11/24, 7/13/24, 7/16/24, and 7/18/24. You signed a misconduct acknowledging these behaviors on 7/23/24. These behaviors are in violation of the GPS minor agreement you initialed and signed on 3/5/24. Charge 2, obey all laws, obedience to the law. On October 28, 2024, you physically assaulted your pregnant girlfriend at your parole-sponsored Crystal's apartment. You grabbed her by her hair and pushed her on the floor, and while she's on the floor, you jerked her head back and forth a couple of times while pulling her hair, causing her pain. This caused her to feel endangered and call 911, but hung up because she was still inside of Maldonado's home, and she was afraid. These violent behaviors are in violation of Connecticut General Statutes 53A-61A, assault in the third degree on a pregnant person, and 53A-181, breach of peace in the second degree. This assaultive behavior is also in violation of your initial and signed conditions of parole, obey all laws. You're subsequently arrested and arraigned on 10/29/24 when probable cause was established and a bond was set. On December 13th, 2022, while on special parole supervision, you were in possession of a Glock firearm as evidenced by pictures on your cell phone. As a convicted felon and offender with the Deadly Weapons Offender Registry, this repeated behavior is in violation of Connecticut General Statute 53A-217, felon in possession of a firearm or ammunition. A person who is guilty of criminal possession of a firearm, ammunition, or electronic defense weapon when such person possesses a firearm, ammunition, or electronic defense weapon, and one has been convicted of a felony prior to, on, or after October 1st, 2013. Weapons. On January 1st, 2023, while on special parole supervision, you were on video with a firearm and ammunition under your control, instructing a child shooting a firearm. The ammunition on the table and the firearm are in the area and vicinity under your immediate control. The authenticity of the firearm is verified by the presence of an explosion, muzzle flash, and ejection of a shell casing, following each round fired. Your presence is verified through the distinct sound of your voice and the tattoos on your left hand. On December 13th, 2022, you possessed a Glock firearm as evidenced by 2 photographs discovered on your cell phone. These behaviors are in violation of your initialed and signed conditions of parole. Obey all laws. I will not use or have in my possession or control any firearms, ammunition, or any other weapon. Charge 4, gang membership. During previous incarceration, you admitted to being a member of the Latin Kings from the time he was young up until 2014 when he denounced his gang membership and/or affiliation. Yet through a search of your phone, you repeatedly and continuously displayed signs, symbols, and/or colors associated with the street gang Latin Kings, as evidenced by tattoos, videos, photographs, social media, and text messages discovered on your cell phone. As recently as October 25th, 2024, your Facebook account name, Honda King, text message received and sent stating ADR, Amodere, pictures of a lion wearing a crown labeled King, black and yellow Pittsburgh Pirates hats, repeated attire and accessories consisting of black and yellow, and hand signs depicted in many of your photographs were sufficient for the Department of Correction to redesignate you as an active member of the security risk group Latin Kings. These repetitive behaviors are in violation of your initialed and signed conditions of parole, gang affiliation. Charge 5, halfway house placement. You strayed from your halfway house pass approved destinations and visited locations you were not approved to visit on 3/13/24, 3/14/24, 3/15/24, and 3/18/24. You signed a misconduct acknowledging these behaviors on 3/20/24. Charge 6, no contact with minors. In a cell phone video taken on January 1st, 2023, you had unauthorized contact with a minor at a shooting range. At no point in time did your parole officer grant you permission to have contact with minor-age children. During a review of your cell phone, it was determined that you communicated with your daughter, 15-year-old J. Riley's, date of birth 3/2/2009, via text messaging on 10/24, 10/25, 10/26, and 10/27/24. At no point were you given permission to be in communication with minor-age children. During a review of your cell phone text messages, it was determined that on Saturday, October 26, 2024, you picked up your 15-year-old daughter, J. Release, from West Hartford Police Department and transported her to your girlfriend's house on Willis Street in Hartford. This was verified by your GPS points and a collect hit from the West Hartford Police Department. At no point did you have permission to be in contact with minor-age children. These behaviors are in violation of your initial and signed conditions of parole, general contact, no contact with minors.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand actual custody order, B, parole violation report, C, notice of parole violation, D, parole and community services assigned conditions, E, Hartford Police Department incident report ending in 7935, Exhibit F, GPS monitoring agreement, G, misconduct and evidence, H, CT judicial department pre-sentence investigation report, I, BOPP decision information summary, J, BOPP revocation hearing summary 6/26/23, K, CTDOC SRG affiliation documents, L, cell phone pictures, M, CAPI photo, N, Allied Universal GPS points 10/26/24, O, CTDOC visitor status, P, cell phone videos, Q, letter from Glock, R, signed halfway house agreement. Did you receive notice of parole violation report, and those other documents, and did you review them, sir?
Yes, madam.
And council has filed the following exhibit pre-marked for identification purposes. That's Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Having no witnesses, I'm going to put on the record, I received the addendum from PCS. The addendum reported on 11/27/24. Offender was convicted of breach of peace second and received an unconditional discharge with all other charges nollied. So at this time, the state will have an opportunity to call to speak to any of the evidence submitted at this time. I'm going to swear in both Mr. Maldonado as well as P.O. Huff in an event that you would like to speak. So can you please both raise your right hand? You solemnly swear to honestly affirm, as the case may be, the evidence you shall give in this case should be the truth, the whole truth, and nothing but the truth to help you God about penalty of perjury?
Yes, ma'am.
Yes, ma'am.
All right, so, P.O. Huff, at this time, would you like to say anything in regards to the charges?
I'm sure. I just want to touch base on the fact that Mr. Maldonado's instant offense back in 2016, he was convicted of illegal sexual contact with a minor, burglary, assault third, and criminal possession of a firearm. He was last remanded to custody on April 13, 2023 for committing a burglary in Windsor Locks. He was sentenced to 1 year by the court. He was released about 11 months later to the halfway house back in March 2024, and just under 8 months later, he was again arrested for similar charges anyways, with assault third and breach of peace, and then the discovery of the firearms and him possessing firearms and being around firearms on his phone show that he has not strayed far from his behavior back from his original offense back in 2016. And although he did receive an unconditional discharge and the assault third charge was nullified, it does not negate the behavior.
Thank you.
Yep.
So at this time, defense will have an opportunity to speak at this time?
Yes, just to clarify things, he was released on 3/5/24 to parole, correct?
I'm sorry, say that again, sir?
He was re-released to parole on 3/5/24, correct?
Yes, sir.
Okay, thank you. So I would contend that any of the conduct that occurred prior to 3/5/24 should not be part of this violation, which would include in charge 2, part B, which would be conduct from December 13th of 2022. So I don't believe that there's sufficient evidence and this should not be covered in this violation. That would be part 1 and part 2 of charge 3, weapons, from January 1st, 2023, since he wasn't released until March of 2024, December 13th, 2022. Also, no contact with minors. That cell phone video was taken on January 1st, 2023, allegedly, and all the conduct in charge 6. So I don't believe, under the preponderance of the evidence standard, I certainly don't believe under the rules of evidence, and that none of this conduct occurred since its release on 3/5/24. As to charge 1, I have no comment regarding the GPS violations regarding the preponderance standard. As to charge 2, he was not convicted of any assault of conduct whatsoever. He received an unconditional discharge for breach of peace. Part B of that occurred in 2022. Even if allegedly Exhibit Q says that it matches the serial numbers and looks like a Glock, smells like a Glock, we do not know, because we don't know whether or not, under the definition of firearms, that was capable of firing a shot back in 2022, which was before this period of supervision. Also, the conduct from 1/1/23 and 12/13/22 from charge 3 should not be considered merely because he was possessing a Glock in a photo. We don't know if it was a Glock. We don't know if it was a firearm. We don't know if it was capable of firing a shot. As to charge 4, gang membership, who, what, when, where, how was that information posted? Was a search of his phone? We don't know, merely because of the coincidence that he in the past, it's uncontroverted that he was in the past a Latin king. We don't know when those were placed on there. We don't know how those were placed on there. I don't believe there's significant foundation to prove charge 4. I don't believe it meets the preponderance standard. Thank you.
Thank you.
I just have a few comments when you get them.
Go ahead.
In regards to the nollie just means I'm not willing to prosecute, does not excuse the behavior. It's not a not guilty charge by any means. The sex offender registry designation, actually not, the security risk group designation was enough for DOC to feel confident enough and sufficient to place him in the SRG program that he's currently in that right now. In regards to the charges that he was on previous, he was still under special parole supervision when these firearms were discovered. Not when they were discovered, but when he was still on special parole supervision, regardless if he was charged with it or not. We were not aware of the behavior at the time, so he was not charged until we became aware of the behavior. So it does not excuse the fact that he's in possession of these items while he is on special parole supervision. Let's see. And also, I have some privileged information. I was talking to the Special
Object.
Licensing and Firearms Unit with the state
I would
police.
object to any privileged information that I haven't been apprised of prior to today's hearing.
Well, if he's gonna notify us both now, I mean, what,
I
from
know
who?
that across, okay, fine.
It
Who's
was
it from?
through the Detective Warrenda from the Special Licensing and Firearms Unit.
I would object as to hearsay.
Well, hearsay is acceptable. Go ahead.
This says that in regards to the firearm that he is possessing, this firearm has what appears to be a functioning slide lock, the gap between the bottom along the slide lock to be pulled down. The officially licensed Glock BB guns seem to have a slide lock that is solid plastic. This firearm has what appears to be a functioning trigger pin since it is set into the firearm. Officially licensed Glock BB guns seem to have raised circles mimicking a trigger pin. So this in conjunction with the letter from Glock is verifying that these are in fact real firearms, and the one that is taken on somebody's lap and the one him holding his hand in his hand, has a unique hand grip on it, which would determine that those two, the ones that Glock had certified as a real firearm and the one him possessing in his hand, would lead a reasonable person to believe that is the same firearm due to the unique hand grip that was on it.
Just briefly, we don't know if those are functional firearms. We don't know if they meet the definition of firearm. We don't know if they're capable of firing a shot. We don't know if they're real. They can look real. They will not be real. Thank you.
And we can always look back at that video as well, which kind of speaks for itself. And the Glock and the detectives for the Special Licensing and Firearms Unit are more experts in this category than I think any of us would be.
Thank you. All right, so I'll be right with you with my findings. Right, so regarding charge 1, I do find that you violated that condition release section GPS based on evidence that was provided in support of the charge D, F, and G. And I do want to note that you have been on supervision since 12/18 of 2019, so all of these charges do apply as you were on special parole supervision at the time of all these instances. On charge 2, I do find you violated condition obey all laws, obedience to the law. Part 1, based on your conviction or breach of P2, received a sentence of unconditional discharge, so all other charges nullied. Part 2, I do make a finding based on evidence that was presented by the state, which is exhibits D, L, and Q. On charge 3, I find you violated condition weapons based on evidence provided in support of the charge, which is exhibits D and P on part 1 and D and L and Q on part 2. On charge 4, I find you violate condition gang affiliation, gangs membership based on the evidence that was provided, exhibits K, L, M, D. On charge 5, I do find you violate condition halfway house placement based on the evidence that was provided, exhibits D, G, and R. On charge 6, I find you violate condition no contact with minors based on evidence provided, which is exhibits D, O, L, P, and N. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So, P.O. Huff, do you have anything you'd like to say in regards to the second part of the hearing?
Not particularly, just saying this is he's exhibiting the similar behaviors that he was originally convicted of back in 2016. And if I could, I would just like to add a no contact with the victim in regards to this most recent assault case, please.
Right, counsel, did it say anything?
Yes. My client is single, 42 years of age. She received support from his mother, father, 3 brothers, and 5 sisters. He obtained his GED in 2003. He had worked in the past at the Home Depot Distribution Center. He worked full-time at Valvoline for 5 months. He had participated in outpatient services at CRT briefly. He also was medication compliant. He wishes to be placed in a halfway house in Hartford, wishes to enroll in Lincoln Technical Institution in auto mechanics, return to his full-time position at Valvoline on Silas Dean Highway in Weathersfield. I don't think a lengthy sanction is appropriate here. I know the PO recommended a 12-month sanction. We would ask for a lower sanction than that. Thank you for your time and consideration.
Thank you. All right, so I've listened to testimony. I have reviewed all the evidence that was presented. I'm going to put on the record, you were out there about 7 months and 24 days before you returned to custody on new charges that do mirror previous offenses you are on special parole for. You did receive the new sentence, as well have a prior violation that is also criminal in nature, and which received a 1-year sentence for that. You did receive 5 misconducts on this period of supervision, were redesignated as a Latin King, and do have a history of weapon possession and violence. Based on all the information, as well as everything that was presented at today's hearing, I will note your officer recommended a year incarceration after dispo of charges. So I'm going to recommend that parole be revoked. You be re-paroled for November 28th of 2025, which is about a year and a month period of confinement as a sanction. I also recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, behavior management program for domestic violence, no contact with your co-defendant, Wilfredo Fernandez, number 381011, no contact with your victim, YRM, DR, and JG, enhanced internet and device monitoring, a general no contact with 33 Fox Hollow Road, Windsor Locks, Connecticut, Albert Halstead and Ashley Sociato without PO's permission, mental health evaluation and treatment as deemed necessary, no contact with minors without PO's permission, problem sexual behavior treatment and restriction on pornography. My findings, recommendations are going to the parole board January 16th. So the board's going to make the final decision. This is just a recommendation. So the board does have the ability to revoke all of special parole. I'm trying to give you time to participate in the SRG programming in the facility before you are re-released back out into the community. So that's why I'm trying to release you back out on relatively, just giving you enough time in the facility to participate. Do you have any questions about anything that was said?
Oh, man.
All right, so you're all set for today. The board will notify you about a week after in writing, or you can speak to your attorney on January 16th or the next day after.
Give me a call on the 17th of January, sir, and I'll tell you what the board decided. Okay, sir?
Yes, ma'am. Yes, sir.
Good
Thank
luck,
you.
sir.
Thank you.
Thank you, P.O. Huff.
Thank you, ma'am.
Is that your parole?
Good morning,
Good morning.
Mr. Burgos.
No, Wilcox.
Oh, Wilcox. Is Burgos? Can you have the officer bring Burgos here if he's in there?
There was no one else down here.
I'll do his case first. All right.
Be back.
Yes. Give me 1 second. Huh? He might be on his way down.
You got a pass? It works.
Hi, P.O. McCue.
Hi, good morning.
Good morning. We are live streaming. I have Mr. Wilcox here. We're going to start his hearing. Okay, we're going to get started, sir, with your preliminary hearing.
All right.
Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Wilcox Joshua, number 389167. Today is January 6, 2025. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Joshua Wilcox, inmate number 389167.
Okay, we have a parole officer present. Can you please identify yourself for the record?
Hi, good morning, Parole Officer McCue, Hartford Parole.
This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there's probable cause to believe you commit an act that violated conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note you've been referred by the Department of Correction for diversion for substance abuse programming and treatment. If by the end of the hearing I determine you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charges, state your PO is written against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue probable cause and state the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
And I was supposed to do the timeout program. This is what this all is. Like, I'm not even sure what
That's what this is for. This is for your placement. You have to be placed in it to continue participating.
Oh, okay.
So your important rights today, right to have an attorney present. Do you want to continue without counsel?
Yes.
You have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence for your case. At this hearing, right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge the state your parole officer is bringing against you and the information underlying each charge. So P.O. McCue, if you could please read the charge.
Number one is for GPS. You were placed on GPS supervision on October 2nd, 2024 due to noncompliance in the community to include substance use residing with your parole sponsor. The review will inside your GPS monitoring agreement on the state indicating an understanding of the conditions. You have failed to charge your GPS appropriately on November 7th, November 10th, November 11th, November 18th, November 20th, November 23rd, and November 25th, allowing your GPS unit to shut down, making your whereabouts in the community unknown. Charge number two is curfew. On August 12, 2024, your sponsor notified this officer that you have not been residing at your parole-approved residence since approximately August 7th of 2024. You did not have permission to reside anywhere besides your parole-approved residence. This time, you have violated your stipulated parole curfew of being at your parole-approved residence by 9 p.m. every night and not leaving the residence before 6 a.m. every day. Charge number three is program participation. You were stipulated to complete Explore programming according to the conditions of your release. You reviewed, initialed, and signed on June 25th, 2024, indicating understanding on them. On July 26th of 2024, Explore programming staff notified this officer you were unsuccessfully discharged from the Explore program due to multiple absences and not attending once intake was completed. You were re-referred to Explore programming on September 25th, 2024. You were unsuccessfully discharged from this program as well due to lack of attendance. Upon release on June 25th, 2024, you were stipulated and instructed to complete a mental health evaluation and treatment as deemed necessary. Multiple attempts were made by this officer on June 25th, September 25th, October 1st, and November 7th to refer you to mental health treatment, and you were instructed to attend your scheduled appointment. As of December 17th, when you were taken into custody, you have not completed the stipulation. September 12th, 2024, you were discharged from the inpatient treatment center, Rushford Center, before the required recommendations and did not inform this officer. You did not have permission to leave inpatient treatment without approval. The charge is number 4 for drugs. December 10th, 2024, you contacted this parole officer over the phone and verbally said it to be inebriated. Your sponsor was with you at this time and was instructed to report immediately to the emergency room or 911 services would be contacted for your residence. Sponsor confirmed with this officer that you would be transported discharged immediately to the emergency room. You were temporarily admitted into a mental health unit with Hartford Healthcare on this date. You then agreed to volunteer to stay hospitalized with Natchitoches Hospital for the next week to receive intensive mental health substance use services. On discharge, paperwork was received confirming diagnosis with a substance use overdose. On December 17, 2024, you reported to Hartford District Office after being discharged from Natchitoches Hospital. After making a stop before reaching the office, you completed a toxicology screen while at the office that rendered a positive result for cocaine, fentanyl, THC, and methadone. You signed a voluntary admission admitting to recent illicit substance use after being immediately discharged from the Natchitoches Hospital for substance use overdose. You also signed a voluntary admission on August 7th, 2024, August 19th, September 12th, and October 2nd, admitting to illicit substance use of cocaine and fentanyl. Last charge is charge number 5, Beaver Mail Event Program. You were stipulated and instructed to complete Explore programming according to the conditions of your reviewed initial design on June 25th, 2024, indicating an understanding of them. On July 22nd, 24, Explore programming staff notified the officer you were unsuccessfully discharged from the Explore program due to multiple absences attending when intake was completed, and you were re-referred to Explore programming on September 25th, 2024, and you were unsuccessfully discharged from this program as well due to lack of success.
Thank you. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, conditions of parole, B, Raymond, actual custody, C, parole violation report, D, notice of parole violation, E, GPS agreement, F, Premier Biotech results, G, Explore discharge report, 2, H, misconducts, 9, I, voluntary admission, 6, J, Hartford Healthcare patient referral report, K, revocation summary, and L is BOPP decision information summary. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes.
Do you need to continue the sharing to obtain any additional evidence?
No.
We have no witnesses. So I'm going to swear in McCue as well as Mr. Wilcox, so you can both speak today if you'd like to. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case would be, the evidence you shall give during this case should be the truth, the whole truth, and nothing but the truth, so help you God on penalty of perjury?
Yes, I do.
PLBQ, would you like to say anything at this time in regards to the charges?
I know the evidence speaks for itself. Mr. Wilcox has kind of a common history of substance use, which he's, very open about, and we've discussed it both openly ourselves. So we're just thinking this is the best for him at this time.
Okay. Good. Okay, it is now your opportunity to respond to parole violation charges against you. However, that you may remain silent. Would you like to respond to the charges, sir?
I never signed a voluntary admission form stating that I had used after the Natchitoches program.
You never signed a voluntary admission for what?
Saying that I used allegedly after Natchitoches program, because I didn't.
So what date are you talking about that you didn't use?
That'd be the 17th of December. The date that I was taken into custody.
I don't think you're being charged for, oh, you are. Let's see. So you're saying on 12/10, you didn't sign a voluntary admission form?
No, on the 17th.
12/17, you never signed a voluntary admission form, you're saying?
No.
Anything else you'd like to say in regards to any other charges?
No.
All right, so I'll be right with you with my findings. You said 12/17, right?
Yes.
So you're saying you never signed this? But I have your signature on the bottom of it?
That was the day that I was taken into custody. I wasn't aware I signed a voluntary admission form because I was aware that the urine I gave was being sent to the lab.
Well, I'm just letting you know there is a signed voluntary admission form on 12/17.
Okay,
that you did sign.
all right.
Just so you know, I don't know when the last time you went through it, but, all right, so what I'm gonna do next is announce my findings. So on charge 1, release direction GPS, I make a finding based on evidence that was presented, which is exhibits A, E, and G. On charge 3, I make a finding of probable cause, release direction program participation, parts 1 and 3. I separate this into 3 parts based on evidence that was presented, which is exhibits A, E, and G. A, G, H, part 1, A, and G on part 3. I make a no finding on part 2 due to there being insufficient evidence to support that charge. On charge, I'll go to charge 2. Release direction curfew and make a no finding of probable cause due to there being insufficient evidence. There is no evidence the offender had a curfew prior to 10/2/24. On charge 3, I already stated. Charge 4, I make a finding of probable cause, obey all laws, drugs, parts 2 and 3, based on evidence presented in support of the violation, which is exhibits A and I on part 2, AFI on part 3. I make a no finding on part 1 as it does not meet the elements of the offense. On charge 5, I make a finding of probable cause, additional condition behavior management program based on evidence presented, which is exhibits A, G, and H. I do find the acts are serious enough to warrant revocation. I have determined you should be detained. You have been referred by DOC for diversion from the revocation process for substance use programming and treatment. This means if you want to participate, apply, and I find that you meet the criteria, I can continue your case while you provide an opportunity to participate in the top program in the correctional facility. If you successfully complete the programming and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programming and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked or if any sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and do you want to apply for it?
I understand the diversion process, yes, and I would like to apply for it.
Okay, so I'm going to announce my findings with respect to your eligibility. If I determine you are eligible, I can accept your application and divert you from revocation. And I have reviewed all the information. My finding is as follows. I find you have no pending misdemeanor or felony charges. I find your discharge date is more than 60 business days from the date of today's hearing. I find there's evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find there's some evidence that you received or provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. I have determined you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask you indicate whether you understand the following by saying yes or no. I understand I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of the top program.
Yes.
I understand that ultimately the DOC will determine whether I have successfully completed the programming and treatment provided.
Yes.
I understand that my participation in this process is completely voluntary.
Yes.
Okay, so your application for diversion is granted. You'll be in the programming and diverted from revocation for no more than 60 business days from your return to custody. So as soon as you complete the programming, I will be notified. I will reinstate your parole. If you do not complete it and you get DRs or anything happens like that and you get booted, you're going to come back for a revocation hearing.
I understand
Okay,
that.
so make sure you take it seriously and complete the programming. All right.
All right. The only question I have is the you said it starts from the time of my incarceration.
Yeah, that's when the 60 business days start from your remand.
All right. I appreciate it. Thank you.
Okay, you're all set. Good luck, sir. Thank you, P.O. McCue. Bye.
Burgos, is it?
Ma'am, you want inmate Burgos?
Yes, please.
All right.
It's on top moving. East.
Have a seat over there.
East.
testify.
Good morning, Mr. Burgos.
Good morning, how you doing?
Morning, sir.
So we're here today for your preliminary hearing, okay? So we're gonna get started on that.
Yes, ma'am.
Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing starting Burgos Joshua number 244208. Today is January 6, 2025. This hearing is being conducted via video at the BOPP Central Office and the Hartford Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Josue Burgos, 244208.
Do you have counsel here today? Please identify yourself.
Yes, Public Defender Rob Famiglietti of the Parole Revocation Unit. Hello, sir.
How you doing, sir?
Good, how are you?
I'm
This is a
all right.
preliminary hearing, which is for the purposes under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant invocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing and placing back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant invocation, you may be held in prison pending further proceedings. You should know preliminary hearing is a reversal proceeding. Anything stated this hearing can be used against you. This hearing is being recorded. This is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to just issue a probable cause to review the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay. You have important rights today. The right to have an attorney. You have counsel here. You have a right to receive the written notice charges of violation. Did you receive the written notice?
Yes, I have.
Okay. You have a right to view the evidence against you, right to submit evidence in support of your case. At this hearing, right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
Okay, so now review the charge, the state your PO is bringing against you, and the information underlying each charge. So charge 1, release section drug testing. Your charging officer reported on 12/6/24. You were asked to render your analysis for toxicology tested. On 12/9/24, the results of the urinalysis returned from Redwood Toxicology Laboratory with the results stating specimen is abnormally dilute. Charge 2, release section drugs. Your charging officer reported on around 10/1/24 used cocaine, on around 10/22/24 used cocaine, and on around 12/6/24 used cocaine. And the state is following exhibits that are pre-marked for identification purposes as Exhibit A, notice of parole violation. B, notice of parole rights. C, agreement to extra custody order. D, PCS signed conditions. E, half-house agreement. F, PCS signed conditions. G, half-house agreement. H, offender misconduct. I, voluntary drug admission. J, Quest Diagnostic Toxicology Lab Report. K, offender misconduct. L, Quest Diagnostic Lab Report. M, PCS signed conditions. N, halfway house agreement. O, offender misconduct. P, Stein halfway house discipline report. Q, voluntary drug admission. R, Redwood Toxicology Lab Report. And S is parole violation report. Did you receive notice of parole violation report, and the other documents I marked, and did you review those?
Yes, I received them.
And we did review them.
Yes. Do you need to continue to contain any additional
But
evidence?
only thing now.
We have no witnesses today, so it's now a defense opportunity. If you'd like to speak at this time?
Yes, that's the charge 1. I don't believe the evidence meets the probable cause standard because abnormally dilute. There's absolutely no evidence that my client tampered or did anything illegal or anything underhanded regarding that urine specimen. In fact, if you look at charge 2, the third part of it, they did find that he used cocaine, I would imagine using that urine because it's from the same exact date. This is an instance where my client, as a result of the first 2 urines, was sent to Out Foundation where he successfully completed a 30-day treatment. And unfortunately, when they released him, they did not give him any Suboxone, or enough Suboxone post-release, which we believe led to the 12/6 use. And that was a positive, and he did not fail to cooperate in the giving of that urine that they're claiming is abnormally dilute. If there could be any number of normal reasons why his urine was dilute without him tampering with it. So I don't believe that should be a basis of violation. Also, this is his first violation since a prior top referral. My client needs treatment. He doesn't need jail. These are basically 3 positives for cocaine. He has a cocaine problem. He's proven that he can enter treatment at our foundation, take it seriously, successfully complete it, be on his Suboxone. I don't see any reason to incarcerate him, and I certainly don't think this violation is sufficiently serious enough to require a revocation hearing. Let's get this man out of jail, get him back into treatment. He was paroled on July 10th, 2024. He was in treatment for about 3 to 5 months before they remanded him. He went to Wheeler afterwards. He was discharged. They gave him the Suboxone. He did it himself to get the Suboxone to prevent the positive urines. After 12/6, 6 days later, he was remanded. Once again, I think treatment is the appropriate sanction here, and I don't believe there's any need to incarcerate my client further. None of this is violent. None of these are crimes. Thank you for your time and consideration.
Thank you.
You're welcome.
So I'll be right with you with my findings.
All right, thank you.
All right, so I'm going to announce my findings. So on charge 1, I do make a finding of probable cause for restriction drug testing based on the evidence that was provided, exhibits D, P, and R. In that is a disciplinary report where you admitted to putting water inside the for the drug test. And on charge 2, I do make a finding of probable cause on Obeah Law's drugs based on the evidence that was provided, DHIJKOPQ. I do want to note, you do have that prior cot placement. You were only included about 5 months before being returned to custody, unfortunately for the same type of behavior while in the halfway house. So I do find the act is serious enough to warrant revocation. I've turned to be detained while you wait for revocation hearing. At the revocation hearing, myself or another hearing examiner will determine if you violated conditions of parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked, when the sanctions should be imposed. It's a technical violation, so that means I'm going to bring you back. We have 60 days from your return to custody. You were back already in December, so I'm going to schedule you for a hearing probably February. It's my soonest. We'll bring you back and determine if there's a violation. Okay?
Yes.
So you'll be held now, sir, okay? This was basically, like I said, a due process hearing to make sure they didn't remand you for absolutely no reason. She made the findings of probable cause and that it was serious. So what they'll do now is they'll schedule your hearing within the next 60 days, okay?
All right.
And once I find out when that hearing is, I will give you a phone call and you'll also talk to our social worker, okay?
All right.
Okay, sir, have a great day.
Try to get involved in programming if you can while you're in there. You know, prepare for coming back out.
I'll be honest with you, like the programs in here, like I've been in jail my whole
It's all
life.
in how you want to use the information. I know you know it. Maybe reset your mindset while you're in there. It doesn't have to be about, I know how programming is. It's about resetting yourself. So try to focus on that before I see you again. Okay?
No problem. No
Good
problem.
luck, sir.
Good luck, sir. I'll see you soon.
You too.
Good morning. Can you hear me?
Yeah, we're good.
Oh,
Yes.
perfect. Mr. Diaz?
Morning.
Morning, you here for your revocation hearing today?
Yes.
Okay, so we're gonna get started. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Diaz Hector, number 244858. Today is January 6, 2025. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing and public access. This hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Hector Diaz, 244858.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better reader evidence must establish that more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing you, place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charges, state your appeal is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, you will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today, right to have an attorney present. Do you want to continue without counsel?
Continue.
Okay, you have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge. State your appeal is bringing against you any information underlying each charge. So charge 1 under the release section absconder, your charging officer reported on 3/31/23 at 4:06 p.m. You were seen via video recording of the facility front door camera walking out of Central Ave halfway house without permission and headed south on Central Ave towards East Main Street, Waterbury. You did not return to the Central Ave halfway house, nor did you contact your parole officer. Your whereabouts in the community have been unknown since 3/31/23. Charge 2 under bail laws, obedience to law. On 9/22/24, you were stopped by Waterbury Police Department for a traffic violation. You were operating with the wrong plates on the vehicle and registration was suspended. After the cops conducted his investigation, it was determined you would be placed under arrest for the following: an active warrant from absconding from parole, interfering with an officer, possession of controlled substance, 4 ounces, no vehicle insurance, operating unregistered vehicle, misuse of marker plates, and driving without a valid license. On charge 3 under bail laws drugs, your charging officer reported on 2/3/23, you arrived at Central Ave halfway house and was given a random urinalysis, in which you signed a voluntary admission for the use of cocaine. On 3/25/23, you rendered random urinalysis and the results came back on 3/31/23 as positive for cocaine. You're in violation of parole condition number 2 of bail laws drugs. Charge 4 under additional conditions halfway house placement. Your charging officer reported 3/31/23 at 4:06 p.m. You were seen via video recording of the facility front door camera walking out of Central Ave halfway house without permission, headed south on Central Ave towards East Main Street, Waterbury. You did not return to Central Ave halfway house, nor did you contact your PO. Subsequently, you are in violation of parole condition number 7, additional condition halfway house placement. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand to custody. B, parole condition. C, notice of parole violation. D, parole violation report. E, halfway house incident report. F, voluntary admission of positive test results for prohibited substances. G is offender misconduct report. H, halfway house discharge plan report. And I is Waterbury police report. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Yes.
Okay. Do you need to continue the hearing to obtain any additional evidence?
I'll continue.
Okay, we have no witnesses today. So now is your opportunity to respond to parole violation charges against you. However, remember that you may remain silent if you so choose. I'm just going to swear you in under oath so you can speak today if you so choose to. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, that evidence shall give, in this case, shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury?
I do.
All right, so in regards to those charges I just read, do you have anything that you would like to say?
No, ma'am.
Okay. So what I'm gonna do next is I'm gonna announce my findings, which is based on the available evidence that I have. And I do want to put on the record, I did receive an addendum from PCS, and in the addendum, it stated on 4/25/24 is when the BOPP absconder warrant was issued, and on 10/29/24, you were convicted of interfering with an officer as well as possession of controlled substance, received 11 months jail, executed, suspended, or 18 months conditional discharge for that. Other charges were not prosecuted. So regarding the charges, so on that charge 1, I do find you violated condition absconder based on a warrant being issued by the BOPP and evidence that was provided in support of the charge, which is exhibits B and D. On charge 2, I find you violated condition of obedience to the law based on your conviction of interfering with an officer, absconding in possession of controlled substance, received a sentence of 11 months jail, executed, suspended, 18 months conditional discharge, as well as exhibits B, D, I. Charge 3, I find that you violated drugs based on the evidence provided, B, F, and G. And on charge 4, I do find you violated condition half-house placement based on the evidence that was provided, which is exhibits B, E, H, and D. So that includes the fact-finding portion of this hearing. Before I make a recommendation, you will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to say anything in regards to, I don't know what your future plans are to go back out in the community or what you've been working on, but this is the time to say that now.
Right now, since I came in, I signed up for the drug rehab programs. Since day one, I did admit it to the parole officers that I had so far that that's my problem, drug habit. Which I was getting help out there. That I fell off the wagon. I do admit it. I never denied none of that. And that I always, and since when they gave me the papers, I told them I'll accept any consequences. And yeah, to keep working, because I do work for myself. Parole knows that I besides doing professional tattoos, I do construction work. From day one that I got on parole, that's what I've been doing. That's how I was able to pay my rent when I did have my apartment. Now I'm going to proceed with it and proceed with drug rehab program.
Were you able to get into any type of programming while you're inside?
They got me on the list for drug rehab. Yes.
Okay.
As soon as I came in, when we did orientation, he said that he placed me on the list because I told him to put me on drug rehab, the domestic domestic abuse program. Yeah. He said that he'll submit me to the list, but it's a long waiting list. So most likely I'll be transferred before I even get on the program list.
Where do you plan on going when you get out?
Don't know yet because I don't have a place to live.
So where do you need? So we put you in a halfway house then. But what area would you want to go to?
Waterbury.
You want to go back to Waterbury?
Yes, that's where my family is.
Is there a specific place you go for treatment in Waterbury?
I was going to Walmart, yes.
Yeah.
I mean, they helped me since day one that I started doing the program. I mean, I find it real sufficient.
Is there anything else you want to say before I make a recommendation?
No, ma'am.
Okay. So I will say you were, out there about 3.5 months before you absconded. You were absconder status for about 1 year and 6 months. You did receive the new conviction with a conditional discharge of 18 months. You do have 2 prior violations, 1 criminal and 1 technical, as well as a misconduct for the drug use. Your officer recommends 12 to 18 months sanction. Based on all of the information that I have, as well as testimony, I am going to recommend that parole be revoked to be reparoled So for September 22nd, 2025, it's approximate 1-year period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with minors without PO's permission, problem sexual behavior treatment, operation of a motor vehicle, behavior management program for domestic violence and anger management, and general no contact with Edwila Munez Montserrat. So I'm presenting this to the parole board January 16th. So January 16th, the parole board is going to make the final decision. So they can let you out as soon as January 16th. They can agree with my date of September 22nd, or they can also have ability to revoke all special parole or do it later. So it'll be up to the parole board. Do you have any questions? Do you understand?
Yeah, I do got a question. If I do get a valid address, I could present it before even halfway house comes through?
If you get a valid address, yes, you can write to the officer in your facility. If
Yes.
you get an address so that they can give it to me. Just write it's for your revocation hearing so that they
Yes.
know it's my unit, and then I can put that information in for you.
Okay.
Okay?
Yes.
Okay, so you're all set for today, sir. You'll know, you're gonna get it about a week after January 16th in writing. I'd say give it a week from the parole board, and then I'll say what the board's decision is, and it'll say your conditions as well, okay?
All right. Thank you so
All right.
much.
You're all set. Good luck, sir.
Thank you. Something I don't.
So we just have hooks today.
Okay,
Thank you.
you're welcome. Folks, you can come in.
Freezing.
I know,
The
right?
elevator was freezing. Got ice box.
Good morning, sir.
Morning.
Morning.
Mr. Hooks.
Yes.
Okay, we're here for your revocation hearing. I have your attorney here, so we're gonna get started, okay?
All right.
Good morning, I'm P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Hooks Gregory number 154805. Today is January 6, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Gregory Hooks, 154805.
And you have counsel here today. Please identify yourself.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Hooks.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is basically place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state EPO is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure?
No.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have received the written notice of charges, the violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge. The state appeal is bringing against you any information underlying each charge. So charge one, obey all laws, obedience to the law. You're charging officer reported 8/23/23, New Britain Police Department received a complaint from victim reporting you stole various outdoor tools from the victim on 8/19/23. New Britain Police Department filed an arrest warrant on the charge for larceny fourth on 3/1/24. New Britain Police Department serves you with the arrest warrant and you had a pending charge of larceny fourth. You arraigned on this matter on 3/4/24. New Britain GA 15 under docket ending in 7769-S. Your next court date is 4/24/24. Based on your behaviors in violation of parole conditional bail laws, I will obey all laws. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, signed statement of understanding and agreement conditions of parole. B, agreement to actual custody order. C, signed parole violation hearing notice and parolee rights. D, parole violation report. E, New Britain Police Department warrant related to case ending in 4549, and Exhibit F is State of Connecticut Judicial Branch case detail related to docket ending in 7769-S. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes.
In counsel, I filed the following exhibit pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses. I will put on the record, I received an addendum from PCS. In the addendum reported on 12/11/2024, the defendant was convicted of larceny fourth, received a 1 month jail sentence, 1 month jail, executed suspended, conditional discharge 1 year for that. So it's not offense's opportunity if you'd like to speak at this time.
The only comments that I'll have in regards to charge one is that my client did enter his plea agreement under the Alford Doctrine, which indicates that although he entered into a guilty plea and the court made a guilty finding, that he did not agree with all or some of the facts alleged by the state. But obviously he was in a position where he knew that he wanted to get to this hearing as soon as possible. And so he did enter into that agreement. Those are my only comments.
Right, so what I'm gonna do next is I'm gonna announce my findings. So regarding that charge one, I do find you violated conditional bail laws, obedience of law, based on your conviction of larceny fourth and received a sentence of 1 month jail, execution suspended, 1 year conditional discharge. So that includes the fact finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you. My client is 55 years of age. He's single. He has 1 child who lives in Vermont, who's an adult. His support in the community consists of his sisters who are in New Britain, his aunts and uncles who reside in the New Britain area as well. He would like to obtain his GED. He last completed the 11th grade, having attended New Britain High School. I would like to point out that my client had a previous violation. He has been in custody since September 1st of 2023. So he's been in custody for approximately 15 and a half months. He was previously violated and had a revocation hearing on October 12th of 23, where he received a 6-month sanction. He was scheduled to be released and re-paroled on March 1st of 24, and this warrant in regards to this New Britain matter was served on him that day. The warrant was signed on January 21st of 24, but was not served on him until the date that he was scheduled to be released and re-paroled. So I just think that's important to note. So my client has been in custody for a significant period of time. He lives with substance abuse issues, and though he has received treatment in the past, he still struggles and could benefit from parole supervision, specifically to receive substance abuse treatment in the community in the form of an IOP program, as well as attending AA or NA meetings in the community. While he has been in the Department of Corrections, he has attended an anger management program, a tier 2 program, and he did work as a tierman while he was held at Osborn Correctional Institution for approximately 6 months. During his time period that he was in the community, during his most recent supervision, he did hold employment working at as a machine operator at a warehouse in Terryville for approximately 2 months, as well as working for Mills Revocation in New Britain as a laborer moving furniture for approximately the same amount of time. Again, in the past, he's worked at Sardilli's. His work history does demonstrate that he does have the ability to obtain employment, and as well as a willingness to maintain employment as well. If he's re-paroled, he'd like to be sponsored in the community by a halfway house in the Hartford area as his first choice, the Waterbury area as a second choice. He tells me that he would like to utilize Steadfast Temp Agency to find employment. He believes that he would be able to return to Sardilli's in Hartford, and that he also has an opportunity working at Fresh Point, Connecticut, located in Hartford. So again, we are asking that he be re-paroled at the next available date. As I previously noted, he has been in custody for about 15 and a half months.
Thank you. So I will put on the record, you do have the prior violation for absconding, which you did serve the 6-month sanction, or you received 6-month sanction for that. And you have been incarcerated, as previously stated, since September 1st of 2023 on that previous violation. So based on the information I have, I'm going to recommend that parole be revoked, to be re-paroled for January 16th, 2025, which is approximately 10.5 month period of confinement as a sanction. Noted the offender has remained incarcerated since since that 3/1/24 date, but it ends up being about 1 year and 4.5 months that he's been in custody, including the other violation. So I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, behavior management program for domestic violence, and no contact with your victims BK and JC. My findings are going to the parole board on January 16th. At that time, the board is going to review my recommendation as well as your case, and then they're going to make the final decision. So they can agree with me and let you out that as of that day, and you would be released that day if they agree with me. If you were here past that date, that means the board did not agree with me and they would want to see you and talk to you. And then they would give you another date if they chose to do that. Do you have any questions?
No, ma'am.
Okay, so if you get released January 16th, they agreed with me, pretty much. Okay, and then an officer will let you know.
Okay.
And if for some reason you don't leave that day, call me, okay?
I sure
Okay.
will. All right.
Okay. All right, good luck, Mr. Owens.
Good luck, sir.
You up?
Thank you. Have a good
You're welcome.
day.
Have a good one. You too.
Good morning.
All right, good morning. Good morning.
Good morning, Mr. Rosegreen.
Yes.
Okay, we're gonna get started. We're gonna get started in 3 minutes. I just have to wait till 10:45 and then we'll get going with your preliminary hearing, okay?
Okay.
Officer Davis.
Local parole officer Davis, PO Meisinger. We're online streaming right now, and I have Mr. Rosegreen here, as well as Attorney Dean. Are you ready to begin?
Yes, I'm ready to begin.
Okay. All right, we're gonna get going, Mr. Green, and start, okay?
Okay. I mean,
Good
Mr.
morning.
Rosegreen?
Rosegreen, yes. Good
Okay.
morning, I'm PO Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Rosegreen, Lamont, number 279798. Today is December 27th, no, it's not. Today is January 6th, 2025. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing, and public access to this hearing is available via video live stream. You please state your full name and DOC inmate number for the record, sir?
Lamont Rosegreen, 279798.
Thank you. We have a parole officer present. Please identify yourself for the record.
Yes, Parole Officer Patrick Davis. I work out of the Hartford District Office.
Thank you. We have counsel here today. Please identify yourself.
Yes, Hannah Dean on behalf of Mr. Rosegreen from the Public Defender's Office. Good morning, sir.
Morning.
This is a preliminary hearing, which is the purpose of under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause or reinstate your parole, we should release you and place you back on parole supervision. If I find probable cause and determine the acts are sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue probable cause in the spirit of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you of my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence for your case. In this hearing, you have a right to call and examine voluntary witnesses, cross-examine diverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so you'll now review the charge the state your PO is bringing against you and the information underlying each charge. So PO Davis, please read the charges.
You want me to read the charges that are on the notice?
Yes.
Okay, on 8/6/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 12:38 a.m. to 7:14 a.m. and then again the same day from 10:26 p.m. to 8:27 a.m. on 8/9/2024. This is a violation of your signed GPS agreement. On 10/19/24, you failed to charge your GPS, resulting in a shutdown of the unit from 8:02 p.m. to 12 a.m. 10/20/24. This is a violation of your signed GPS agreement. On 11/20/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 1:08 a.m. to 8:32 p.m. 11/21/24. This is a violation of your signed GPS agreement. On 12/12/2024, you removed your GPS unit without permission from this officer. This is a violation of your signed GPS agreement. On 5/1/2024, you were instructed of your GPS curfew of 9 p.m. to 6 a.m. At no time were you provided with any other curfew or given permission to be out past your curfew. On 10/26/2024, you did not return home until 9:12 p.m. This is a violation of your signed GPS agreement. On 10/28/2024, you did not return home until 9:15 p.m. This is a violation of your signed GPS agreement. Those were GPS charges and curfew violations, and that's charge 1 and charge 2. Charge number 3, drug testing. On 12/12/2024, you were instructed to report the Hartford District Office to render a urine screen drug testing. At this time, you refused the urine screen at Hartford Hospital after reporting to the office. You were transported via ambulance to Hartford Hospital and again refused the urine screen by medical professionals. This is a violation of your signed PCS conditions. Charge number 4, program participation on 5/17/2024. You were referred to Wheeler Clinic in Hartford for a mental health evaluation. You were instructed to complete and follow through with all recommendations. You failed to attend your scheduled appointment as instructed. On 11/26/2024, during reporting with this officer, you verified verbally that you still had not completed your mental health treatment as advised by your previous PO. A mental health evaluation was on your PCS conditions. This is also a violation of your PCS signed conditions. Obey all laws. Charge number 5. On 12/11/2024 at approximately 4 p.m., you arrived at the location of 300 Sheldon Street, Hartford, Connecticut, 06106, HDO. You were acting erratically. Your behavior suggested you were having either a drug-induced or mental health incident. Parole officers responded to the scene and requested HPD and EMS due to your behavior. You were observed blocking traffic in the intersection with a parked vehicle, running out of the vehicle and attempting to run onto the adjacent highway, I-91 exit ramp, not listening to verbal commands or instructions, speaking in a way not to make any sense, crawling and exposing yourself and making lewd gestures to multiple responding staff members and those in passing cars that were unable to leave the scene due to your blocking of the road. It was determined that you may be a danger to yourself and society. EMS transported you to Hartford Hospital without incident. Once you were there, you were uncooperative with hospital staff and were discharged due to your noncompliance. Your behavior is in violation of breach of peace, Connecticut General Statute, Section 53A-181, and public indecency, Connecticut General Statute, Section 53A-186. Please see Exhibit M. On 12/12/2024, you reported to the Hartford District Office. Upon arrival, you were observed in the elevator of the Hartford District Office acting strange and attempting to take your shirt off. Once in the lobby of the Hartford District Office, you began your non-compliant behavior by making other offenders feel extremely uncomfortable for their safety. You were forcefully moving lobby chairs around and raising your voice and screaming. You were then observed ripping your GPS monitor off your ankle and threw it in the lobby that was filled with other offenders. Based on your behavior, medical services were called, and you were once again transported to Hartford Hospital. While in transport to your assigned hospital room, you attempted to kick at other patients in the hospital hallway and knock down the medical equipment attached to them. Once in your room, you used disrespectful language by swearing and using profanity at officers and medical professionals and threatening medical staff to not touch you or render any type of medical aid. Based on your behavior, the staff was once again unable to render any aid. You were provided with a urine cup, and you proceeded to throw this cup at the parole officer, just missing this officer and hitting another officer in the leg with it. You were provided with a bottle of water, and you once again threw this towards staff, causing them to quickly move out of the way, resulting in it hitting the wall. Based on your behavior, you are in violation of breach of peace, Connecticut General Statute, Section 53A-181, disorderly conduct, 53A-182, assault of public safety, and emergency medical, public transit, or healthcare professional, Section 53A-167C. Please see Exhibit M. Charge number 6, search on 12/12/2024 at Hartford District Office, Hartford Hospital, and Hartford Correctional Center. You failed to comply with a search/pat down of your person as instructed by your PO. You failed to let your PO or other officers search your person, violating your assigned PCS conditions search. And I think that is.
There's another part that is the first violation that you issued in a second violation with a later date. And
No, I did. I'm sorry, man.
That's okay.
Let's see the part I left out.
I just labeled it part 2. It's on the 12/12/24 in obedience to the law.
part today. I'm trying to go back here on.
Obedience to law on 12/12/24. I mean, if you can't find it, I can read this part. It's fine.
I got it. I'll read it. I just found it.
Okay.
This is the part I left out here on charge number 5, obedience to the law. I just missed the paragraph. I'll read now. On 12/12/2024, upon arrival to the Hartford District Office, he was observed via video camera footage opening the door to the office. In the entrance way, an employee of Hartford District Office Maintenance and Custodial was performing his daily job duties. This employee is contracted through Easter Seals, which is a company that employs disabled and mentally compromised individuals. You are observed physically putting your hands on this employee and moving/pushing him out of the doorway. You obviously frightened said employee because he immediately put his hands up and wanted no part of getting in your way. After pushing said employee outside, you were seen entering the elevator. You then exited the elevator and kicked the wooden door by the entrance and proceeded upstairs to the lobby. Based on your behavior, you were in violation of breach of peace, Connecticut General Statute, Section 53A, 61A, assault in the 3rd degree of an elderly, blind, disabled, mentally retarded, or pregnant person. That's the part I left out. Sorry about that.
Okay, thank you. And the state filed the following exhibits pre-marked for identification purposes as Exhibit A, CT signed remand extra custody order. B, CT signed conditions of parole. C, notice of parole violation with offender rights. D, parole violation report. E, PCS misconduct reports, which includes the Allied Universal EM manager. F, CT decision information summary. G, GPS monitoring agreement paperwork. H, pre-sentence investigation report. I, discharge paperwork after visit summary from Hartford Hospital. J, 2 disciplinary reports received 12/13/24. K, video and pictures. L, staff witness statements. And M is Connecticut General Statute printouts. Did you receive the notice of parole violation report, and those other documents I marked, and did you review them, sir?
I'm a little confused with keeping up with all that.
Did you receive the evidence I just read?
I received some paperwork and I didn't have the full time to go through everything. So, but some of what I'm hearing it sounds correct. And then some.
Mr. Rosegreen, I wouldn't say anything as to the allegations here. They're just asking if we received this evidence and had an opportunity to review it, which I have done. So I just want to make sure you got the paperwork too, correct?
Okay, yes.
Okay, thank you.
I need to continue this hearing containing additional evidence.
No, thank you.
Okay, we have no witnesses. So I'm going to swear in both Mr. Rosegreen as well as P.O. Davis, so that if you do choose to speak today, you have to be sworn under oath. So can you please raise your right hand for me? You solemnly swear, solemnly affirm, as the case to be, the evidence you shall give for in this case should be the truth, the whole truth, and nothing but the truth, so help you God from penalty of perjury?
I do.
So at this time, you can put your hand down now. The state will have an opportunity to make a short statement and testify with respect to probable cause and spirit of the allegations. So P.O. Davis, would you like to speak?
Sure. Just an opening, I'd like to just say a couple of things. For almost a 36-hour period, Mr. Rosegreen was a menace and danger to himself and society. On 12/11/24, Mr. Rosegreen showed up to the office after I did a home visit about 3 or 4 hours prior to that. Mr. Rosegreen stated he didn't have any issues, but he showed up later that evening on 12/11/24. When he showed up, he was acting erratically in the street, blocking traffic, and people trying to get, to and from work, publicly displaying his genitals and acting uncontrollable. At that point, he was EMS took him to the hospital, and police were also called. That continued the next morning. I called in, back into the office to see, what was going on and what transpired the night before. The non-compliant behavior begun again in the office that morning. He disrupted the whole flow and operations of the office, cut his GPS off and threw it, and we had to clear out the lobby of other offenders at that time. EMS was called again, fire department was called. He was then again transported to Hartford Hospital, where again, the non-compliant behavior began, assaulting staff, being non-compliant with doctors and other medical staff, trying to kick and assault patients that were in the hallway of Hartford Hospital. So again, the non-compliance in the hospital as well. Last thing I'll mention is when we did drop him off to Hartford Correctional Center, it was without incident. However, he did the next day on 12/13/24 receive 2 disciplinary reports for interfering with safety and security and insulting language and behavior on 12/13/24. That's all I'd like to say for that. Thank you.
Thank you. All right, it's now defense's opportunity if you'd like to speak at this time.
Yes, thank you very much. As to charge 1, I don't have any comments as to the probable cause standard. As to charge 2, curfew, no comments to probable cause, but I do just want to note the alleged late reporting for the curfew. On each of those occasions on 10/26, my client was allegedly only 12 minutes late, and on 10/28, sorry, my client was also allegedly only 15 minutes late. As for the third requirement, drug testing, I would argue that the probable cause standard has not been met. We don't have anything in evidence indicating that my client refused to submit a urinalysis either at the parole office or at the hospital. In fact, the discharge summary that's included at Exhibit I from 12/12 is silent as to whether a urinalysis was taken or attempted. So I would argue that the standard has not been met for that charge. For program participation, I would also argue that the probable cause standard has not been met. My client does indicate that he was engaged at Wheeler Clinic at some point during his parole supervision doing groups there. And I would just argue that no evidence has been submitted as to that charge. As to 5, obedience of the law, I also broke this into 3 separate parts. As to the first part, I would, for all 3, argue the standard hasn't been met. As to the first part, I would just note that the incident on 12/11, my client was not arrested despite the police being called and being present on scene. That is the standard probable cause that they typically use for arrest, and it was found that my client was not appropriate to be arrested at that time. So I would argue that the standard has not been met. I would also argue that as to Exhibit K, the photos and evidence are not time-stamped. So it's difficult to provide context as to when those photos were taken, what they are taken of. So I would ask that as to that charge, they not be considered for evidence. As to charges, second part of that charge and charge 3, or part 3 of that charge, I would argue for each no finding should be made. No evidence was submitted as to part 2, my client allegedly assaulting this individual. There's nothing in evidence to support that. And as to charge 3, that incident on 12/12, we don't have that specific information or video and evidence or any signed statements from that date as to substantiate those allegations. So I would argue that that standard has not been met. And as to charge 6, I would also say that the standard hasn't been met for that one. No evidence was submitted as to my client refusing a search. So I would make those prior arguments. Thank you very much.
Thank you. So based on the information that I have, testimony provided, I am going to announce my findings. So regarding charge 1, I make a finding of probable cause, release direction GPS based on evidence that was presented, exhibits B, E, and G. I make a finding of probable cause on charge 2, release direction curfew based on the evidence that was presented, which is exhibits B, E, and G. Regarding charge 3, condition release direction drug testing, make a no finding of probable cause based on there being insufficient evidence to support this charge. There's no evidence the offender refused a drug test. On charge 4, condition program participation, and make a no finding of probable cause based on there being insufficient evidence to support the charge. There's no evidence that the offender was not participating in a program or anything in regards to that. On charge 5, I make a finding of probable cause, obey all laws, obedience to the law based on evidence that was presented in support of the violation. This is exhibits part 1, KLM, part 2, KM, and part 3, KM. However, on that part 3, the part at the hospital, I make a no finding on. So this is only for the 12/12 while the offender was at the Hartford district office. So it's kind of like a sub. Regarding charge 6, can search and make a no finding of probable cause based on there being insufficient evidence to support the charge. No evidence the offender can use a search anywhere. But I do find the act is serious enough to warrant revocation. Attorney should be detained while you wait for revocation hearing. So at the rev hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked or the sanctions should be imposed. So we're going to bring you back, sir. This is a technical violation. So 60 business days we have from your date of return to custody to hold a revocation hearing. And then we determine if there's a parole violation or not, and if any sanction is going to be imposed. Okay? So we're going to bring you back and we'll talk to you and determine what's going to happen, right?
Okay.
And I will meet with you once more before that hearing so that we can prepare for it, okay?
Okay.
P.O. Davis, would you like to be at the revocation hearing?
Yeah, sure.
Okay. All right. So we're all set for today then.
Thank you very much.
So thank you. Have a good day.
Take
You
care.
too.
Have a good day, everybody.
Thank you. I can go.